Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, high-yield professional responsibility core rules. Let's begin. Professional responsibility is issue-dense. A single fact can trigger several duties. A lawyer who invests in a client's company has a business transaction conflict, potential personal interest conflict, fee issues if stock is compensation, confidentiality concerns, and possible competence concerns if giving business advice. Train yourself to layer duties. California distinctions matter. Start with California Rules of Professional Conduct and California Business and Professions Code Section 6068. Then compare ABA model rules when useful. The exam often rewards statements like, California requires the lawyer to preserve client secrets at every peril, subject to a narrow permissive exception for preventing a criminal act likely to cause death or substantial bodily harm. The ABA exceptions are broader. Conflicts with current clients. California Rule 1.7 prohibits representation directly adverse to another client or materially limited by responsibilities to another client, former client, third person, or the lawyer's own interests unless the lawyer obtains informed written consent and the lawyer can provide competent and diligent representation. Some conflicts are non-consentable. Business transactions with clients. Under California Rule 1.8.1, a lawyer must not enter a business transaction with a client or acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless the terms are fair and reasonable and fully disclosed in writing. The client is advised in writing to seek independent counsel and given a reasonable opportunity to do so. And the client provides informed written consent. Confidentiality and secrets. Business and Professions Code Section 6068, E1, is broader and stricter than ordinary evidence privilege. Section 6068E2 permits disclosure only to the extent the lawyer reasonably believes necessary to prevent a criminal act likely to result in death or substantial bodily harm, after trying to dissuade the client when reasonable. Candor and false evidence. A lawyer must not knowingly make false statements to a court or offer evidence the lawyer knows is false. If a client intends to commit perjury, the lawyer must try to dissuade, may seek withdrawal if permitted, and must not facilitate false testimony. Duties of confidentiality complicate disclosure, but candor to the tribunal and no assistance duties remain critical. Fee analysis. Identify the fee type: hourly, flat, contingency, advance, retainer, referral, or division. California fees must not be unconscionable. ABA fees must be reasonable. Check whether a written agreement is required under California law. Contingency fees must generally be in writing and cannot be used in certain family law or criminal defense contexts. Fee divisions among lawyers not in the same firm require client consent and cannot increase the total fee improperly. Unearned fees must be handled properly, often in trust unless a true retainer or compliant flat fee rule applies. Safekeeping property. Client funds must be kept in a client trust account separate from lawyer funds. The lawyer must promptly notify the client of receipt of funds or property. The lawyer must maintain records and promptly pay undisputed amounts. If there is a dispute, the disputed portion stays protected until resolved while undisputed amounts are distributed. Organization client. The client is the organization, not its officers, directors, employees, or shareholders. If a constituent acts in a way likely to substantially injure the organization, the lawyer may need to report up within the organization. The lawyer must clarify identity of the client when constituents may misunderstand. Confidentiality still belongs to the organization. Prospective and former clients. A prospective client can create confidentiality duties even if no representation follows. Screening may help in limited circumstances, but do not assume screening cures all California conflicts. A former client conflict turns on substantial relationship and material adversity. Informed written consent versus written disclosure. Informed written consent means the client agrees in writing after disclosure of relevant circumstances and reasonably foreseeable adverse consequences. Written disclosure informs the client in writing but may not require written agreement. California rules use both concepts. Choose precisely. Sexual relations with clients. California restricts sexual relations with clients unless a consensual sexual relationship existed before the attorney-client relationship. This can be tested as a personal interest conflict and discipline issue. Aggregate settlements. A lawyer representing multiple clients may not participate in an aggregate settlement without informed written consent from each client after disclosure of all material terms, including each person's participation. Gifts from clients. A lawyer must not solicit a substantial gift from a client or prepare an instrument giving the lawyer or a related person a substantial gift unless the lawyer is related to the client. Watch for wills naming the lawyer as beneficiary. A lawyer cannot solve a conflict by deciding the representation is good for the client. Consent and consentability are separate requirements. A lawyer's personal financial interest in fees, media rights, stock, or loans can materially limit representation. Confidentiality survives termination of the attorney-client relationship. A lawyer may receive confidential information from a prospective client before declining representation. If a lawyer knows a witness will lie, the lawyer cannot call the witness and hope cross-examination fixes it. California lawyers have duties to report certain misconduct, comply with court orders, and update state bar information. Discipline can arise even outside client representation. For a conflict essay, draw a client map. Current client conflicts get the strictest treatment. Former client conflicts require substantial relationship analysis. Personal interest conflicts require informed written consent, if consentable. Business transactions require fair terms, written disclosure, advice to seek independent counsel, opportunity to do so, and informed written consent. For confidentiality essays, ask, what information? From whom? Is it privileged? Is it confidential? Does an exception apply? Under California, do not disclose unless the narrow death or substantial bodily harm criminal act exception applies or another law requires disclosure. If disclosure is not permitted, the lawyer may still need to withdraw, avoid assisting fraud, refuse to offer false evidence, or make a noisy withdrawal only if allowed. For court-related essays, candor is paramount, but not simplistic. If the lawyer discovers false evidence already offered, the lawyer should remonstrate with the client, seek correction, consider withdrawal, and take remedial measures required by law and ethics. Compare ABA if relevant. End by naming consequences: discipline by the state bar, disqualification, sanctions, civil liability, fee forfeiture, or withdrawal. A complete California answer shows both rule knowledge and professional judgment. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.